My name is Jeff Morgan. I'm from Dallas, Texas, and I'm going to discuss Senate Bill 1936. This was authored by Senator Bryan Hughes, and what this is, this bill is a bill entitled an act relating to the beginning and ending possession times in certain standard possession orders in a suit affecting the parent-child relationship. Now basically what took place is that this bill, it got passed out of both the House and the Senate, got passed out of the Senate unanimously. There was one person that voted against it in the House. My understanding is this has made the expanded standard possession order the new default in cases of divorce. Now, I would like to call this not just the expanded possession order, the new standard, but I would like to call this the new and improved best interest of the child. Because anybody who's been following this stuff knows that the family law attorneys, or the anti-family law attorneys, and the anti-family law lobbyists, in particular Steve and Amy Bresnan and their ilk, the people that they've called to testify in the past, have praised the standard possession order as being in the best interest of the child. My representative, Anna Maria Ramos, was so gung-ho about the best interest of the child. She was defending the standard possession order and everything else as the best interest of the child. That's very interesting because, again, this is what I would call the new and improved best interest of the child. The standard possession order used to be the best interest of the child. Now, as of September the 1st, 2021, I believe that's the effective date, we will have a new and improved best interest of the child. This is a dialogue between Representative Ramos and Representative David Cook. Now, Representative David Cook is a Republican. He also is an attorney, and his law firm does family law. Representative Ramos is a family law attorney, and she talks about this, a family law practitioner. There was also Chairman Nieve, and Chairman Nieve too is a family law practitioner, which leads me to question once again, we have three people who could benefit by bad family law. They could benefit privately in their businesses by passing things publicly that would benefit their businesses. I really believe that this is the conflict of interest, that we have anti-family law attorneys that vote on these issues. I believe that it is a huge conflict of interest, and I believe that it's forbidden by the Texas State Constitution, Article 3, Section 22. But here is a dialogue between Representative Ramos and Representative Cook. And by the way, Representative Ramos and Representative Cook, to the best of my knowledge, were both against equal shared parenting. They were both against 50-50 shared parenting. But now they are embracing the expanded standard possession order as if this is the new and improved best interest of the child. They don't want to have equality, but they do want to have the new and improved expanded possession order as being something that you are automatically opted into and that you have to opt out of if you don't want it. This would be something that was different. It would change the law right now. So the dialogue between Representative Ramos and Representative Cook, as captured in the House Journal, is as follows. Representative Ramos says, we both served in juvenile justice and family issues, and there were similar bills that discussed conservatorship. And could you explain to the body what exactly your bill does? You said non-custodial and custodial. For those of us here who are not family law attorneys, because family law attorneys, they are the high priestly class of the family law, that with their special rights and their words and the best interest of the child and stuff like that. But for those peons out there, among the representatives who are not family law attorneys, what does this mean? What does this bill mean? Representative Cook. So a non-custodial parent, obviously, is the parent that does not have custody. And so the presumption is that a non-custodial parent will have a standard possession order. Once again, the standard possession order, we have heard from these people many, many times. The standard possession order is the best interest of the child. Cindy Barilla Graham, she talks about how wonderful the standard possession order is, how enlightened the state of Texas is.
Our law as it exists right now is really top-notch. We are truly the best state, and we have legislators who have worked really hard at having and getting the law that we have. So I think it's great that we preserve the law, because really the law as it exists allows us to do the best that we can with regard to children and when parents have the children.
And if you want anything other than that, oh, she can get it for you. You just have to pony up. Just write your checkbooks and give her a check. It's going to be at least $10,000, maybe more.
So people come in and they see me And they come and they're like, blah, 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 I want to fight for custody, I want to fight for custody. And so I'm like, okay, well, pony it up and get your checkbooks out so you can write me a retainer, you know, of $10,000. So you really want to spend $10,000 over 3.5 days? That's fine, I'll take your money, let's go pony it up. But, you know, just know it's going to be long, it's going to be expensive, and it could be well more than 10. It's probably going to be well more than 10. So just let's go. But it's their choice, right? That's how I make a living.
Cindy Barilla Graham, she's a big advocate of the standard possession order, except now that it's no longer in the best interest of the child. I wonder what Cindy is going to be doing and saying, and what she's going to be teaching the anti-family law attorneys in the future. So anyway, the presumption is that the non-custodial parent will have a standard possession order. And currently under Texas law, the non-custodial parent has the option to opt in to certain expanded periods of possession. This bill makes it to where it's an opt-out as opposed to an opt-in. So here's Representative Ramos. So if I am, let's say, in a situation where, many times it's the father, I get to have the child, as we know, every other weekend, right? So you get to have the child. It's your child, but you get to have the child every other weekend. That's what the standard possession order is. You get to have your child every other weekend. And again, this was considered the best interest of the child for years and years. It's been advocated for by these anti-family law attorneys and the Bresnans and the Texas Anti-Family Law Foundation. But as we know, every other weekend, first, third, and fifth weekend of the month, and not every month has 5 weekends, but if there's a fifth weekend, you get the fifth weekend as well. Typically, it could be Friday to Sunday night. How about that? You get to have your child Friday night, Saturday night, and Sunday night. First, third, and fifth weekend. Isn't that really something? That sounds like the best interest of the child. What does this bill do regarding that visitation schedule? Well, isn't this interesting? Now you're a parent with a child and you get a visitation schedule. You're no longer a parent with a child that has a normal parent-child relationship. You now get a visitation schedule because the Texas legislature has deemed that a visitation schedule is something that should apply to you once you go through divorce. And this, again, for many, many years was in the best interest of the child to have this stinking standard possession order that they snookered people with, that they lied about to people regarding this being in the best interest of the child. So you have that. What does it do regarding the visitation schedule? That we pretty much is what we call standard possession order. You're saying here that that's the default, but what your bill is going to do is to make the extended standard the default. Is that correct? Yes, exactly, says Representative Cook. And Representative Ramos, again, anti-family law attorney, or lawless attorney, Representative Ramos, and the extended standard visitation schedule looks like what? You're still a visitor, but that's okay. I mean, you're extended standard visitor right now. Well, as you said, first, third, and fifth weekends, usually at 6 p.m. on Friday evening till Sunday at 6 p.m. and Thursday evening from 6 to 8 p.m. This bill would make it to where a non-custodial parent would be able to pick up their child from school on Friday and return the child to school. So what it's going to do, instead of having to wait till 6 p.m. on Friday, you can pick them up from school. And instead of having to return them on Sunday at 6 p.m., you can take them to school the next day. This is actually much better than what they have right now. It's still a visitation schedule, but it is better. This is, like I said, the new and improved best interest of the child standard that we've been lied to about for many years. This was never supposed to be in the best interest of the child. Now, all of a sudden, as of September the 1st, 2021, shazam, it is now in the best interest of the child. And that would be the default, and the parent would have to opt out of that. So it allows them to spend more time with their child on those alternative weekends. Imagine that. The state legislature is now going to let you spend more time with your child. These legislators who don't know your children, do not know you, do not know the relationship, they're going to, in their beneficence, grant you more time with your child. And Representative Cook says absolutely. And Representative Ramos, here it comes. Beating her child. Well, as a family law practitioner or anti-family law practitioner, which is probably a more accurate phrase to describe her, maybe anti-family lawless practitioner. I think this is wonderful, and that parents are provided an option here to opt out if they want fewer weekends. I know that there is a lot of miscommunication or misunderstanding when parents are not able to exercise or don't want to exercise more visitation. Again, you're not just a parent, you're a parent, a visiting parent. But if you don't want to exercise more visitation or possession, and ultimately, there have been some threats to, well, threats really? There have been some threats to, go to a separate bill. This is a threat going to a separate bill. Now, the bill she's talking about would have been 50-50 equal shared parenting. That is a threat, evidently, to Representative Ramos. But there are some threats to go to a separate bill when it comes to more 50-50 and all that stuff. We had a hearing in JJFI where a lot of people, and that was true, there were a lot of people, there were about 140, 150 parents that were there. Many people wanted to testify for it. Not everybody could because the hearing ran so long that we had to actually stop. There were some bills that didn't get presented. We were the last people in the Capitol that evening. So we had about 140 parents, I think maybe 75, 80 got to testify. But this was a threatening bill of 50-50, equality, right? We had a hearing in the JJFI where a lot of people testified they wanted more. Imagine that. You have a parent testifying that they want to have more time with their children. What? Is this an abusive parent or what? They want more time with their children. And this is something that the legislature is now going to sit back and benevolently say, yes, we deem that you can now have more time with your children. What a wonderful legislature we have after they have lied to us for so many years about this very issue. But there was, let's say, is in the best interest of the child. Now here comes Representative Ramos. Representative Ramos loves the phrase in the best interest of the child. Personally, I got involved in at least one exchange with her about the best interest of the child where she tried to shut me down and I turned around and tried to shut her down. She tried to tell me that, well, we know what the best interest of the child is. After I told her that the best interest of the child is subjective, she cited the Hawley factors, which are factors supposedly that judges use to determine the best interest of the child. The whole thing is nonsense. It's a snookering of people. It's we put the trappings of law, the trappings of formality. It's nonsense. It's just complete garbage and nonsense. But it seems that perhaps now Representative Ramos has started to see the light, that maybe there was some subjectivity to the best interest of the child. Now that the best interest of the child is being changed, the new and improved best interest of the child is being done right here. It's in the best interest of the child. That's what a family law attorney looks at. So a family law attorney looks at this, right? Isn't that what the family law attorney looks at?
Now, obviously, the overriding factor in the family code is that we always consider what's in the children's best interest. It's in every case that we have that we go in front of any court for, the overriding thing that we're considering is what's in the children's best interest. And that's supposed to be the primary consideration, whether we're talking about conservatorship or possession of and access to the children. And really, we're even going to think about best interest of the children oftentimes in child support purposes too.
Representative Ramos cannot even define what the best interest of the child is, but she's talking about this is what we look at, right? We look at the best interest of the child, and this is what a judge looks at, right? The best interest of the child. And Representative Crook, again, who was a lawyer with a family law, they do some anti-family law as well. Exactly. So they're both talking about the best interest of the child. I defy either one of them to tell me what the best interest of the child means objectively, not subjectively. And again, as I've mentioned many times in the past, in the Texas Family Code, they talk about the best interest of the child directly or indirectly about 140 times or more. Nowhere is it ever defined. And it's very interesting because the person who determines what the best interest of the child is not the parent. It's always a stranger. It's an attorney, because an attorney is looking out for the best interest of the child. An attorney who does not know your children. It's always a judge. The judge who does not know your children. He knows the best interest of the children.
I think the thing to take away that I want you to know is that I believe our current law provides us the best, absolute the best system in the United States. And it allows judges to decide each case on a case-by-case decision. And if the judges decide they want to do something different than what the standard possession order provides, because perhaps people have different jobs that don't follow the standard possession order, then the courts certainly have it in their power to do so. And our law currently allows the judges to consider lots of different factors, as you've seen, and gives the judge the opportunity to do so.
It may be a child custody evaluator. Child custody evaluator who charges you thousands and thousands of dollars. I've seen child custody evaluators that have charged over $50,000 to perform their magical analysis and to determine who is the better parent. I'm going to say this just as an aside right here. Number one, in the state of Texas, we have unilateral no-fault divorce. Forced divorce, divorce on demand, divorce for any reason, divorce for no reason. So if you have a no-fault divorce, even if it's a forced no-fault divorce, you have told the judge, Judge, there's really no fault here. There's no fault here. My spouse is not a bad parent. I'm not a bad parent. This is what you're admitting to, right? But now the judge needs to determine, based on this no-fault petition, they've got to find fault in a parent to make sure that somebody gets the award, the children. Somebody gets custody of the children. This has been the lie of the anti-family court for a long, long time. They talk about the best interest of the child, and yet when they say that there's no-fault divorce, then they start to find fault with the parenting. It's just plain nonsense. Well, anyway, it's getting a little bit dark out here. I may not be able to read the whole thing. I had hoped to start a little bit earlier than this. And Representative Ramos says, and your bill here is really addressing the best interest of the child so they can spend more time with that parent, either father or mother. So Representative Ramos, again, is starting to see the light. And I have this specifically for Representative Ramos because for a long time she's been in darkness, but now she is starting to see the light, and she's talking about the best interest of the child with the new light shining is so that the child can spend more time with that parent, either the mother or the father. And once again, Representative David Cook says that's correct. And here's Representative Ramos once again, and many times the best interest of the child is not one night. What the heck does this have to do with anything? This best interest of the child is one night, 2 nights, it's this, it's that. This is absolute craziness. But this is how anti-family law attorneys make their money. They take this nebulous definition, which nobody can define, which they can't define either, and then they try to create conflict between two parents, because conflict makes anti-family attorneys a lot of money. And Representative Ramos will tell you just that, I'm sure, if she's honest, if she is seeing the light, and if she's walking in the light, and if she's telling the truth, I'm sure she would look glad to tell you that, you know, conflict creates more fees for attorneys. And I'm sure that Representative Ramos, the anti-family attorney that she is, the ethical anti-family attorney that she is, the one who is now embracing this brand new best interest of the child standard, would tell you that she has never done anything that would create conflict between parents to drum up bills, to increase fees. Isn't that right, Representative Ramos? And I'm sure Representative Cook would say the same thing about his law firm, and I'm sure that Representative Niave would say the same thing about her practice. Anyway, to get back to this bill, and Representative Ramos now again talks about the best interest of the child, and many times the best interest of the child is not one night, one house, one night, the other, one night, the next, one night, the next. So she takes a worst case scenario and she tries to play to the crowds because her representatives that are around here, they're not family law practitioners such as she is. She's given them the instruction manual right here. This allows for a child to have consistency and regularity in their schedule, but also allows them to spend valuable time with the other parent, correct? So Representative Ramos, I think, is trying to redeem herself because she was so awful during some of the hearings. And perhaps even Representative Cook is trying to redeem himself a little bit too, because he was not the best person on that committee, according to many people that were there. Now, maybe I've heard some things, I've seen some things afterwards. Maybe Representative Cook is trying to redeem himself. Maybe Representative Cook didn't realize how poorly he came across. But it looks like perhaps Representative Cook is trying to redeem himself. I'm kind of wondering as well if maybe the Bresnans realized, man, we're in trouble with this one. We still want to keep conflict in here. We want to have a little bit of conflict, but we're going to want to pretend. We want to pretend that we're actually helping the parents out. But we want to keep the conflict here because conflict, as Stephen Bresnan, the lobbyist, and as Amy Bresnan, the lobbyist, as they both know, Conflicts creates money for their clients, and their clients are the anti-family law attorneys, the divorce attorneys. That's why they get paid the big bucks. That's why Steve and Amy Bresnan make money representing these people to keep the cash flow coming to the anti-family law attorneys. And Cook says, yes, I believe that's correct as well. So Ramos is now going to redeem herself at last, once again, fully in front of all of these people and say, well, I think this is a wonderful bill. I think it's very good for family law. I think it's very good for family law for families in Texas. It's very good for family law for families in Texas. So Representative Ramos is now trying to almost act as if he's excited about these things. So we have this bill, and it's almost 50-50 at this point. It's the extended standard possession order. And so now we have an amendment. And this amendment was proposed by Representative Middleton, who was the sponsor of House Bill 803, which was for 50-50 shared parenting. And he had, I believe it was 21 or 22 co-sponsors on this bill. Chairman Niave intentionally kept that bill to the end of the session so that it could time out, because the committee never voted on it. That was a trick that she learned from Chair Dutton in the past, and that he was probably coached in by the Texas Anti-Family Lawless Foundation lobbyist Steve Bresnan, and possibly his wife as well. His wife doesn't really say too much in public, but Steve every so often does. But his wife, Amy, says a lot of really nasty things on Twitter. If you want to see something that's nasty, you should see Amy Bresnan's Twitter feed at times. It can be nasty. It can be really low. It can be despicable, to be honest with you. It's pretty vulgar. I'm not quite sure if it's vulgar, but it's really pretty bad. Anyway, so Representative Middleton and Representative Raymond, and by the way, one is a Republican, one is a Democrat. So this was a bipartisan amendment that was offered. They offered the following amendment to Senate Bill 1936. And they talked about the idea of, on page 1, between lines 17 and 18, insert the following subsection. If a court appoints the parents joint managing conservators under section 153.134, and each conservator resides not more than 50 miles from the primary residence of the child, a court shall first consider an order that provides that each conservator has the right to equal possession of the child under a schedule specified by the court or a schedule agreed to by both conservators. Conservators meaning parents, right? If a court finds that equal possession of the child is not in the best interest of the child, the court may enter an altered standard possession order under subsection A and shall make findings of the reasons equal possession of the child is not in the best interest of the child available to each party. So what the judge has to do is, basically he's saying, if you have joint managing conservators, they live within 50 miles of each other, the default should be equal shared parenting, unless the judge determines that it's not in the best interest of the child. Again, whatever that means, because first I would like to see a judge actually define what that means, because a judge can't do that. But the judge would have to also provide reasons that it's not in the best interest of the child if he denies it. How many judges are going to do that is what I wonder, because first off, it creates a lot of work for them. They don't know what the best interest of the child means. It can be challenged all over the place. So here we have Representative Raphael, I believe his name is Anchia, of Dallas. He's a very liberal, progressive Democrat. He is a member of the LGBTQ community. Committee down there in Austin. So he raises a point of order against further consideration of Amendment 1 and under Rule 11, Section 2 of the House Rules on the grounds that the amendment is not germane. So it's very interesting, because Anchia says that this amendment, this bipartisan amendment, this somehow is not germane. Now we're talking about possession of a child, and they're talking about making the expanded standard possession order being the default. And they're saying, well, wait a minute, if we're gonna have this, if the parents live within 50 miles of each other, 50-50 should be the default. Now, Representative Anchia, a Democrat, and again, a very progressive, liberal, anti-family Democrat, I would say, based on what he said, is trying to pretend that this is not germane. Now, I will say one thing, to the best of my knowledge, Aunt Chia is not an anti-family law attorney. He may have been supported by some of these people, but he was not an anti-family law attorney. But I have no doubt in my mind that he was the stooge that they chose to put forth this amendment. And because this had been debated so late in the whole session, basically the point of order, the amendment was withdrawn. Since the point of order was withdrawn, the amendment number 1 was withdrawn, they took a vote. Now the vote was 144 yeas on the House, 1 nay in the House, and 1 who was present who was not voting, and that would be, I believe it was the Speaker of the House, yes. Now there was 1 nay, and that nay was Representative Stephanie Click. So every Republican, every Democrat, every representative in the House voted for this bill except for Representative Stephanie Click. Now, Representative Stephanie Click, perhaps she had a good reason, I don't know, but it was something that I think that she should answer to. And I will tell you that in the past I've had contact with Representative Click. I've not found her to be a bad person or anything like that. She's helped me with a CPS issue at one time. And I think that it's very fair that we ask her, why did you vote against this bill? There could be a very good reason for voting against this bill. You know, if you got rid of no-fault divorce, yes, you could say, hey, wait a minute, this is not the deal that we should be looking at here. But as long as you have no-fault divorce in the state of Texas, you should also say, well, if there's no-fault divorce, if that's what you're using, then you do not use parental fault when it comes down to custody of the children. And if Representative Click wants to make that argument, I would respect that argument. But other than that, I really do think that Representative Click should be asked as to why she voted the way that she did, why she voted against this bill. Children need both parents. Children need access to both parents, generally speaking. Children want both access to both parents. And it's in the best interest of the children to have access to both parents. But I would say the best interest of the child is for them to be raised in an intact family with their own natural mother and father together in an intact household. You don't call stepdaddy daddy, you don't call stepmommy mommy, you don't call engaged fiance either mommy or daddy. That's my daddy's or my mommy's fiance or significant other or boyfriend or girlfriend, whatever it may be, maybe their new husband, new wife, but that is not the child's daddy. The child's daddy and the child's mommy are the natural person. So anyway, this bill also went to the Senate. It is Senate Bill 1936. Once again, the Senate passed it unanimously. So once again, there was one person in the whole Texas legislature, and this would be Representative Stephanie Click, who voted against this bill. And again, I don't want to know what her reason is, but why she voted against this bill, but I think it's a fair question to ask her. Governor Greg Abbott, who has been responsible for some of the fiasco, in my opinion, in our family law, he actually signed it. So I believe it's effective September the 1st that this will go into effect, that the new default for the new best interest of the child will be the expanded standard possession order. So I wanted to give you the update about this. I was even unaware of this until just a couple of days ago. Somebody from Europe wrote to me about this, and I was not aware of it, so I had to talk with somebody else. And yes, indeed, this is now going to be the new default in the state of Texas. The expanded standard possession order is now considered the new and improved best interest of the child. And once again, this just goes to show that we really don't even know what the best interest of the child is. It is a very fluid definition. It is something that can change at a whim. Just as the legislature decided that we now have a new best interest of the child standard, they ought to take this one step further and ask themselves, since when is divorce, no-fault divorce, forced divorce, in the best interest of the child? Why do not the children have a say and say, we do not want our parents to get divorced, we want them to get counseling, we want them to fix their marriage? So the best interest of the child should be expanded. The best interest of the child should be that a child is reared with his or her natural mother and father in an intact family, and that if mother and father don't get along, they don't put their selfish interest ahead of the children, they actually learn to get along. And that we change laws in the state of Texas, that we abolish the unconstitutional, what I believe is unconstitutional, unilateral, no-fault divorce, and that we really really look out for our children, not just give lip service to it. Representative Ramos, I'm looking forward to maybe some commentary from you on how you decided to embrace this new best interest of the child standard, this new and improved best interest of the child standard, and if you would like to go on record as well as saying you were mistaken about the old best interest of the child standard. Anyway, that's it for right now. Senate Bill 1936 will be effective, I believe it's September the 1st. It will make the expanded standard possession order the default opt-in. There may be some times that will not take place, but that is what the intent of this bill is. And so that's it. Thank you so much for listening, and that's it. Thanks so much. Bye.
That's where we start, is with the standard possession order. And I will tell you, all judges are different. I mean, some judges stop and start there with the standard possession order, and others use that as a building block on which they can create additional time for parents who've shown the ability to communicate and to interact with one another, and for a child to do well. So usually that's what the judge is looking for. Are we going to optimize good quality time for a child with a parent when we go beyond the standard possession order?
The standard possession order, just the regular standard possession order, is the first, third, and fifth weekends from 6 on Friday to 6 on Sunday. Now, if your parents were divorced, or if you were divorced, then you may know this, but there are people out there who don't know this. And so this is the actual standard possession order that everybody is talking about right now as exists currently in our law in Texas. The standard possession order includes Thursdays during the school year, not during the summer months, but during the school year, from 6 to 8 on Thursdays. The parent who's not the primary gets 30 days in the summertime of their choice. They can break that up into 2 separate periods, or they can take one 30-day chunk of time. And if they don't designate by a certain date, then their default is July. The parent gets either Father's Day or Mother's Day, depending upon their gender. And no, I don't want to discuss transgender issues right now, in which they have to elect, because I'm not going there just yet. Our code doesn't discuss that yet, and maybe someday we'll do that, but we're not going there now. And then alternate, we alternate Thanksgiving every other year. And then we also, we split up the holiday, the Christmas holiday, depending upon whoever got Thanksgiving. So whoever got Thanksgiving then doesn't get the children until the second half of the Christmas break. And that second half of the Christmas break, the children are just exchanged on the 28th of December at noon. Now, if you do the math under the standard possession order for this year, this calendar year, it's 43%. Now, this is just the standard possession order, okay? Now, we also have the standard possession order with the overnight election. The election is the father's election. So, the standard election order, the standard possession order with the election provides 23 more days than the regular election. It is totally the non-primary parent's election, meaning they can decide if they want to do it or not. It can be combined. And what the election really is they get first, third, and fifth Fridays at the time school gets out until the time school resumes on Monday morning. They get Thursdays during the school year at the time school gets out on Thursdays until the time that school resumes on Friday mornings. They get 30 days in the summer, just like the other standard possession order. They get either Father's Day or Mother's Day. They get alternate Thanksgivings and Christmas, just like the other standard possession order. But how does that shake out? That shakes out to, if you'll see at the bottom of that last slide, that's 179 days. And so, if you do the math on 179 days that they actually have their children, that's 49%. So in 2013, that's 49%. They see their children on those days with the election. Now, that's 3.5 days difference. And I just have to tell you, really, these numbers, I want you to know, these numbers do vary according to how the calendar falls. And as I was preparing for this, I will tell you that in 2014, when I did this slideshow originally, was it 14 or 15? I don't recall. The numbers were not quite what they are now. When I did it originally, the percentage was 47% and not 49%, okay? So just want you to know, depending upon how the calendar year falls. But I want you to look at this, because we're not done with what our standard possession order does with the overnight election for people in this state. So understand what we have and how much people get to see their children. I call it eyeball to eyeball time. I do that with my clients. Eyeball to eyeball time with your kids. So we have 179 days, but you get to add on some. Why? Because on my little highlighted calendar that we saw up there a little bit ago, I don't highlight those Fridays when they get to take their children to school. Now, I highlight the Fridays that are their Fridays because it's the first, third, or fifth, but I don't highlight those Fridays on Thursdays where they take their child, you know, they get Thursdays overnight to Friday morning when school resumes. I don't highlight those Friday mornings when it's not their Fridays, right? So, but they get to spend Friday morning taking their child to school, having breakfast with them, dressing them. So I highlight those Fridays. If you talk about Fridays, they get to add those Fridays. Usually they're going to get either Memorial Day or Labor Day, one of those days, so you can add that on. Somewhere in there, usually there's some school holiday that they may or may not get in there. But usually also think about this. If they don't otherwise have possession of their child on their child's birthday, and that's just one child. If they have more than one child, they could get more days here, but they at least have one child or we wouldn't even be here. You get to at least add one day, potentially, and so potentially they could even have as many as 200 days of eyeball-to-eyeball contact with their child under our current standard possession order with the overnight election that our legislators came up with and that exists currently. I think it's a pretty awesome plan myself. So the big secret is, last I checked, 182.5 is obviously 365 days out of the year. So 182, divide it in half, right? So obviously 200 is more than half of the days of the year. So people are seeing their children eyeball to eyeball time more than half of the days of the year under the standard possession order. So it's kind of, to me, a no-brainer that this is a great plan. if you're going to be divorced, okay, great. You may not be able to see your child every single day, but you're going to see your child 200 days out of 182.5 days of the year, or out of 200 out of 365 days of the year. You know what? That's really not so bad. So what's the big elephant in the room? Why is there all these people always complaining about the standard possession order? Oh my God, I'll never get to see my kid. Right? Because they always whine and complain. Trust me, because we see that as family lawyers and judges. That's what we hear. They think if they have 50-50 time, they don't have to pay child support. That's what they all think. Well, guess what? The law doesn't say that. In Texas, what the law says here, basically, is that the court may order either or both parents to support a child in the manner specified by the order until, basically, the law is in Texas. Normally, somebody's going to need to pay child support till a child's 18 or when they graduate from high school, whichever is later. Also, if they become emancipated, then that obligation goes away, and emancipated would be maybe they get married early, if they join the armed forces before they turn 18, right, that emancipates them, or if a child dies, or sometimes child support can be paid or order paid indefinitely if the child is disabled. The courts still look at and will consider things when it comes to child support, such as the ages and needs of the children, the ability of the parents to contribute to the support of their children, any financial resources available for the support of the children, the amount of time of possession of and access to the children, and obviously that last one on this slide is a pretty key factor here, because the courts can consider that. So the court can consider all of those things, and the Family Code also talks about the support guidelines are just that. They're just guidelines to determine an equitable amount of child support to be paid. And the courts will also look at the obligee. The obligee is the person who receives the child support. The obligor is the person who pays it. The person who receives the child support, the court can look at that person's net resources, including potential earning potential, daycare expenses, any auto or housing or any other benefits furnished by an employer. The courts can look at the cost of travel to exercise possession, any extraordinary health or educational expenses, any expenses for a son or daughter beyond secondary school, and provisions for health care insurance, which, I mean, God knows that's expensive these days. Also, the courts can consider any cash flow problems or debts or debt service assumed by either party and any other reason consistent with, hello, here we go again, here's that best interest of the children, taking into consideration the circumstances of the children, of the parents rather. So the court can look at all these factors when trying to decide, okay, child support, anybody get to pay it? Is anybody going to pay it? So if there is some sort of deviation from the standard possession order, the courts can decide to deviate from the standard support guidelines. So Judge, are there any things that you look at specifically when you're trying to just say child support when deviating from a standard possession order?
Sure. When we talk about the parents who agree to the 50-50 possession, as Cindy told you, a lot of parents don't think about that child support issue, and they agree neither party's going to have to pay because each of us is going to have the child half the time. But what they're overlooking is not everybody's coming into that type of thing on an equal plane. Somebody is a lower compensated spouse, and they're going to have a hard time when they have the child 50% if they're having to rely solely on their own income to provide for the child, meet the child's needs, enjoy some of the things, while maybe the highly compensated spouse who has the child the other half of the time is able to take the child to Disneyland and lots of other things. I have often mentioned from the bench, before you all finalize your agreement, think about the effect of no child support being paid by either party and what that's going to mean for the quality of the time that the child is going to have with each of those parents. And sometimes they come back with a child support figure. When courts have had to decide that, they have simply, they have a lot of different remedies. No statute tells us exactly how to do this. When we have kids who are spending half their time in one place and half the time the other. But they'll often figure out what the child support would be under the guidelines for each parent. Let's say they have one child. So if mom had the child and had to pay child support to dad for one child, it'd be so much. If dad had to pay child support to mom for that one child, it'd be so much. And offset the two and require some amount of child support to be paid to the lesser earning spouse. That's one remedy. So the factors that Cindy has given are all good. I will tell you that most cases are resolved by a resort, just an absolute resort to the guidelines, the way it says. It's, you figure out what somebody's net resources are, and you figure out the percentage depending on the number of children, from 20% to 35% of net resources. And when you go beyond that, then you would need to start talking about the actual expenses that it takes for a child, for example, to go to private school, to have a private education, to meet some special needs for the child. All of those factors are there. And these factors allow the courts to deviate from a strict application of the child support guidelines.
Know that our current law, as it exists, affords us a great system, really the best system in the United States, and really we are lucky that our legislators have taken the time previously in the past to make it what it is today.